Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. The opening topic today will be collecting on your deadbeat tenants. Hello, everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio. Always nice to have these every Saturday at 3 p.m. Today's date, December 28th, 2024, which is the reason I played that song, because we are approaching New Year's Eve in just 3 days. And the name of the song, ladies and gentlemen, was Same Old Lang Syne, performed by Dan Fogelberg. It was released in 1980. And the story behind the song was that in 1975, he was visiting his parents on Christmas Eve, and he was in Peoria, Illinois, and wanted to make eggnog. So it was late at night. He went out, all the stores were closed, and he found a convenience store. But at the same time, there was another person going into the convenience store whose name was Jill Anderson. She was his high school sweetheart. And they were both going to the same convenience store at the same time to buy eggnog. Well, they exited the store together. They tried to find a bar. They couldn't find one, so they actually drank a six-pack in her car, which is the song lyrics. But very beautiful song, and let's get ready for New Year's Eve. But in the interim, we're going to start the show. And the show, as always, we're going to have an opening topic. Then we're going to open it up to questions and answers. If you are in the Zoom room, as opposed to YouTube Live, if you want to talk to me, please just electronically raise your hand. You can do that now. And the sooner you do, then your chances of being discussed will make it so that I do get to you. The topic today is collecting on your deadbeat judgments. Collecting on your deadbeat judgments. So, what do I mean by that? Well, these tenants, they are just deadbeats to a degree, and they just race out on your debts, and they owe you money. So, how do you collect on it? Well, my firm obviously does collection, and the collection is based on obtaining a judgment. So in order to collect your debt, unless the tenant is willing to give it to you voluntarily, you're going to need to have a judgment. So how do you get a judgment? Well, if you did file an unlawful detainer, an eviction lawsuit, then you can immediately start collecting on that judgment. But if you don't have a judgment, let's pretend that the tenant just vacated, which is wonderful since he wasn't paying you rent, and owes you money. So what do you do then? Well, in that situation, you need to get a judgment. So how do you get a judgment? Well, the easiest way to get a judgment is through small claims court. It's going to cost you less than $100. They do have a jurisdictional limit for small claims court, and that is $12,500. So if you are an individual filing, you can file it up to $12,500. If you are a business entity, like an LLC or a corporation, then you're limited to $6,500. So $12,500 for individuals, $6,500 for business entities. Now, if we're talking about rent that was owed during COVID time, which is anything from March 1st, 2020 through September 30th, 2021, then it is unlimited. So if the tenant owes you $50,000 in rent, there is no limitation with regard to filing in small claims court. Now, the other thing that you need to know is that you're only entitled to 2 small claim courts actions per year, unless you're seeking $2,500 or less. If you're seeking $2,500 or less, you can file as many small claims court actions as you like. But if you are seeking more than that, then you're limited to 2. Now, Let's pretend the guy owes you $75,000. It's not COVID rent. So what else could you do? Well, then in that situation, you'd have to file a civil lawsuit. Civil lawsuits tend to be expensive. You're going to need to hire an attorney in most situations. Small claims court is really simple because in those cases, you don't need to have an attorney. In fact, they don't allow attorneys in small claims court. All the paperwork is prepared by the court clerk. You can do it online, but if you go to the small claims court, the court clerk will prepare it for you. And again, it's less than $100. So if it's anywhere close to the jurisdictional limit of small claims court, then you definitely want to file there. Even if the guy owes you $20,000, it's not going to be cost efficient to hire a law firm to obtain a judgment. So it's better, in my opinion, to go to small claims court and you're limited to 12,500, but it's certainly better than nothing. Okay, so now you got your judgment. Judgments are good for 10 years, ladies and gentlemen, 10 years, and they can be renewed at the end of that 10-year period for now an additional 5-year period. Now, all judgments bear interest for every day the tenant didn't pay you. And that interest is 10% per annum, 10% per annum. So if that was a $1,000 judgment at the end of the first year, you would be now an $1,100 judgment. However, if the judgment was entered into in the year 2023 or further in time, then it's only 5% interest. And if you do renew that judgment that was gaining 10% interest per annum, if you do renew it, then the entire time period of that judgment from its inception will only be 5% interest. So keep that in mind if you are renewing your judgments. Okay, let's move on. How do you collect on the judgment? Well, you got a judgment. It's a valid judgment. You know it's bearing interest, but how do you collect on it? Well, the issue on that is simple, and that is you ask the tenant to pay you. Hey, I got this judgment for, $100 and I would like payment on that. Well, if he pays you, then that's wonderful. Then you can call it a day and file a full satisfaction to that judgment. But the problem is if he doesn't pay you, okay, then in that situation, you're going to need to go through collection proceedings. Okay, so how do you go through collection proceedings? Well, the first thing you need to do is you need to find assets. So what kind of assets are we talking about? Well, places of employment, bank accounts, and maybe real estate. I don't really care where the tenant moved to, because the landlords will always say, I don't care where the tenant moved to. Well, we don't really care where the tenant moved to. We want to know where his assets are. Now, there's one situation where you would need to know where the tenant has moved to, and that would be if you're doing a small claims court, the tenant's moved. In order to proceed forward with that small claims court action, you're going to need to serve the tenant with that small claims court action. If you don't know where they are, then it's going to be difficult. I've always allowed existing clients of my firm, if they call us for no charge, we'll see if we can do a data check to find out where they moved to. But for most parts, most people, you're going to need to, before you file a small claims court action, make sure you know where they work. But when you're talking about assets, I don't care where they live. Again, I'm just looking for where they work, what banks they bank at, and also any real estate. So how does my firm do it? And we do collections, ladies and gentlemen. Well, we can verify their social security number, even if you don't have it, through their address where they moved from, through their cell phone number, believe it or not, or through an email address. So if I have any of those, I can generally locate this person's social security number so that we can then proceed forward with other collection procedures. But again, even if you don't have the social security number, you had it on an application, or maybe you bought the property and you never got that, we can definitely locate their social, because having their social is invaluable in terms of collecting. Also, we want to check to see if there's any bankruptcies, because if there's any bankruptcies that have been filed, then of course, if that bankruptcy was filed prior to obtaining the judgment, then we are not allowed to collect. So that's very important. But again, all we need is where the tenant moved from, what his former address was, or maybe his cell phone number or his email address, and we can locate a social from that. Okay, so now that we have a social and we've determined that there's no running bankruptcies to be concerned about, then we need to run a credit report. Now, we're a licensed collection agency. We can only run a credit report legally if we have a judgment. If we don't have a judgment, we can't run a credit report. But once we have that judgment, we can run a credit report and we can find from that credit report open bank accounts, places of employment, and possibly even a real estate that this person owns. There's other ways that we can do it other than a general credit report. And that is also, there's a company called the Work Number. You can put in that social security number and you can find out also another way to find out places of employment, and they'll verify that that person is working there. So that's the basis upon which we do collections. Number one, we got to get a judgment. Number two, we got to locate assets. Once we locate those assets, then we can attach. For a place of employment, it's called a garnishment. For a bank account, it's called a bank levy. We can also put an attachment on any real property that the tenant owns or will own. Now, judgments, as I mentioned, are good for 10 years. And sometimes when you're doing collections, you start the collection case the first minute you get the judgment. Well, there's nothing. The guy doesn't have anything. And therefore, some people get discouraged. But the trick is with judgments is that you run it every year. And maybe the guy has no wherewithal this year, but he will have something, some tangible assets, maybe in year two, maybe in year five. And we in our firm check every single year and we collect on a monthly basis, mid six figures every single month. So it's very important to be diligent with these and not to get discouraged when you have a judgment. And it's certainly worth it to get a judgment. I know my firm, as most collection agencies, charge on a contingency basis. By the way, if you do have some judgments and you do want to use our firm, if you go to our website, evict123.com, and up on the top it says start a collection case. You only have to upload the judgment that you have, and we'll immediately start collecting on that. Okay. The state of California doesn't make it easy to collect on judgment. So I want to share my screen with you now. And let's move this over here. Okay. I want to show you this chart, which will elaborate the problems in terms of what the state allows us to do or not. So let's share that screen. And there we go. Okay, so this is a chart. It's a little bit confusing, but what we're going to do is we're going to look at the last column only, the monthly. If your tenant is earning 3328 or less, that would be right here, this figure here, then you cannot collect a penny. Zero. He's judgment proof. So a lot of these tenants, knowing this law, they'll get two jobs and they'll earn 3,300 from the first job and 3,300 from the second. And therefore, you're not going to be able to collect, even though he's earning more than that. But again, if you're earning 3328 gross per month, you're uncollectible. So in other words, it doesn't matter that you have a valid judgment issued by a court under the rules for the state of California. Totally unfair. The guy gets away scot-free. Now, if you're earning from on a monthly basis 3328 to 6656, that's this figure here, okay, then you're entitled to 40% of the amount above 3328. That's the amount above 40% of the amount above. So if you earned $100 more than that, you'd be entitled to a maximum of $40, okay? However, if you're making 66.56 and 1 cent or more, then you're entitled to 20% of your disposable income. So the disposable income that's after tax, so what you actually take home. So if your take home pay, let's pretend is $7,000 per month, okay, you'd be able to get 20% of anything over 66.56, okay? You get actually 20% of 66.56 of the disposable. So what your actual take home pay is. Okay, let me stop sharing the screen here. And we are now going to call it a day with collecting on judgments against your deadbeat tenants. And we're going to open it up to questions and answers. We know the rules. If you're opening up to questions and answers, you have to electronically raise your hand, and I'll be happy to take you. We'll see if we can get through everybody today, but I am going to cut it off at 4 p.m. because I'm skedaddling to a Laker game. Uh, this show is for informational purposes only. It's not a substitute for legal advice. If you do have a case with me, we only discuss general questions on law and nothing else. And last but not least, if I do call on you and if you do have a camera, I would ask that you turn your camera on so that we'll be able to see each other. And with that, I'm going to open it up to Marks Armand. I'm going to ask you to unmute yourself.
Hey, Dennis, can you hear me?
I'm fine. By the way, can everybody see me? Can you see me?
Yes.
Good.
Longtime listener, first time caller. I have two questions, so I will go through them quick. I have a 4 unit building in Leimert Park. It's City of LA, RSO. Two of my units are always late. They're both at 2,500 a month. One of them hasn't paid since November. So as of next week, they'll only 7,500. One of them hasn't paid December. So as of next week, they'll only 5 grand. Both outstanding balances are over the fair market value of 2625 for 2 bedrooms. I want these units vacant. So, what's my best path forward? And can I refuse partial payment?
You certainly can refuse partial payment. So you're below the threshold, correct?
Yes.
Okay, so the problem with that is that the tenant can always pay late, and if he pays on the 25th of the month, you're never in a situation where you can serve a 3-day notice. What you
Mhm.
can do, however, is you can serve a notice to perform or quit for the late charge. That's assuming you have a rental agreement with a proper late charge in that notice.
Yes.
So you can do that. That's one thing, and we've been filing lawsuits based on just a late charge only to get around the issue dealing with the being below the threshold. Also, of course, if the tenant tries to pay you that partial payment, never accept it. So this way, when January 1st rolls around in your scenario, then we would be able to uh, if the tenant comes with 1 month's rent, well, on January 1st, he owes you 2 months' rent. So on that basis, you can properly reject the tender.
Perfect. Okay. Second question. This is a fun one. I'm working to buy a house off market, single family house in LA City, just outside of Beverly Hills. It's owner occupied. He has two occupants staying in the house with him, non cooperative, no leases, no rent paid for years. I watched a video from you a couple weeks ago. I mentioned tenancy at will. What's the best path forward to vacate these occupants in the house so I can buy
Okay,
it?
this is not a tenancy at will. The issue
Okay.
is, do these occupants ever paid rent? Were they supposed to pay rent?
Here and there, $100 here, $100 there. One of them's been there for 20 years. It was friends that have overstayed their welcome and now are pretty much squatters.
Right, but at one point in time, there was an agreement made, correct me if I'm wrong, with the current owner saying, hey, yes, this is what your rent is per month, and he did make some payments.
Verbal, never written.
Okay, so but verbal, written, it's the same. So if you buy the property and these people don't move, then they're treated as tenants. So you got to get from the current owner exactly what the oral rental agreement is about. But what you can do also is you can make a demand to pay that. You'll obviously have to inform them that you're the new owner of the property and with your contact information. That change of ownership form is on my website at evict123.com. But then you can raise the rent to market level. So it's a single family homes. You'd be able to raise the rent to market level. Or if you were planning on moving in, then we could just serve a 60-day notice and we would pay them relocation money, which is equal to 1 month's rent.
Last question. This rent property would probably rent for $12,000 to $15,000 a month. They're staying in a single room each. What would be a fair market rent based off of that?
12,500, whatever the fair
Great.
market is.
Thank you, Dennis.
Okay, you take care. Okay. 1 second, ladies and gentlemen, doing a little housekeeping here for a change. Okay. I think I got them all. Okay, let's move on to Mark Shields. I'm going to ask you to unmute yourself.
Hey, Dennis, can you hear me?
Hello. Yes, I
Yeah.
can.
Another long time, first time. Thanks for your time this afternoon. I recently purchased a unit. It's a single family home up front with two ADUs in the back. One ADU is occupied, one ADU is empty. I'm moving in the empty ADU right now while I'm fixing it up, but there's a family in the single family home. It's in Venice. I'm optimistic, hopeful that we can come to a cash for keys vacancy agreement. And I think that process, as I understand it, would be I have them sign a disclosure form that I file with the LA Department of Housing. But then I also, the vacancy agreement itself, do I file that with the LA Department of Housing with the disclosure agreement before or after? And then how do I handle payment? Is payment done when they leave the premises, or typically how is that done?
Okay, with regard to disclosure, you have to hand that to them, get them to sign it, and then you negotiate technically, and then do a voluntary vacate agreement or a cash for keys agreement. That does have to be filed with LAHD, the Los Angeles Housing Department. In terms of when the money is paid to the tenant, that's up to the two of you. So if in fact you want to pay it as he's walking out the door, he hands you the keys, you hand him the money. But most tenants are going to want the money up front, so maybe you want to give them half up front and half behind. The problem with this voluntary vacate agreement or cash for keys agreement, and we've talked about this before, is that if the tenant, let's say, takes half the money, and then on the day he's supposed to move out, he says, "I'm just kidding. Can you start an eviction?" And the answer is no. That's not one of the reasons to start eviction under the Los Angeles Housing Department rules. So can you ask for the money back? Yes. Well, what if he doesn't give you the money back? Well, then you're stuck suing him in small claims court or some court to get your money back. So it becomes insane.
Yeah.
We have an agreement, which we call a voluntary vacate agreement, and we have an indirect basis of evicting this tenant if he doesn't move when he's supposed to move. So you might want to check with my office on that as opposed to doing the numerous cash for keys agreement that you can find online.
Okay, and I'm hopeful we can get that in the event that we aren't able to get to an agreement. They are a qualified tenant. They have a minor in there, so I know there's a substantial fee I'm going to pay them. But if they want to push for more than that and we can't come to an agreement, they've got stuff all over the premises of the yard. And the way the lease was written, that I assume when I bought the property, is that they have access to a shed. Now, how much, I guess there's three tenants or three different units on this yard. How much access to the shed does he have? And I'm thinking about actually taking the shed down. So if I take it down, am I still obligated to provide him access? The way the lease agreement's written, it does not say I have to provide him access to a shed, just that he has access to the shed that's already existing. And then lastly, there's a lot of stuff around the yard that I want cleaned up, and I don't want to turn his world upside down because I'd rather come to an agreement with these guys. But in the instance that it's not an agreement that we come to, what process do I have between telling him to move his stuff? He can't put it in the shed. It's got to be off the premises between there and ultimately a for-cause eviction.
Okay, well, a lot of questions rolled into one.
Yeah.
But with regard to the shed, if he was promised the use of the shed, then you can't take it down unless you give him a corresponding decrease in rent. So whatever the rental value is for that tenant, then you would have to decrease the rent because he's entitled to a shed. You might want to put it in a different location, But in any event, if you just take away his quote storage rights, then he's entitled to a corresponding decrease in rent. Now, with regard to the junk around the yard, many rental agreements say that you're not allowed to store your items in the common areas. So you're a new landlord coming in. I would send him a warning letter first that you're not in compliance with the terms of the rental agreement, and this place is unsightly because of that. And then give him a week or so to clean it up. If he doesn't, now you've got a reasonable case for eviction. We would serve a 3-day notice to perform or quit for him to clean up the yard. At the end of the third day, you take a picture of the junkyard, and then we're good to go for an eviction.
Yeah, I mean, just for background, I had a bunch of cleaners kind of clean out the yard. They had some weeds that they said were carrots and beet plants that got cleaned up with it as well. And I gave them time to replant things if need be. And they're saying, oh, this shouldn't have been moved. This shouldn't have been moved. I'm like, this stuff's not even allowed in the yard to begin with. So
Exactly.
yeah,
Yes,
yeah.
so point out their rental agreement to them.
All right. And then the shed though, they can't take up all the shed, right? I mean, it's just they have access to store some of it because I don't want
Well,
them.
that, was loose language in the
Yeah.
contract. So, if he takes up all of it, he takes up all of it.
Well, I'll
So
put my stuff in there so you can, I guess is what but I
I
got
guess
you.
first come, first serve.
Yeah, makes sense. All right. I appreciate your time. Thank you very much.
Good questions, Mark. Moving on to a regular, Mr. Sam. How are you?
Good afternoon, Dennis. It's not letting me turn my camera on.
Is that, well, other people have, so,
Yeah, I don't know what's going on. Yeah, it says you cannot start your video because the host has stopped it.
oh, that's interesting.
Yeah.
Let me see if I can find it here.
Okay.
Uh, I think I did it. See if you can do it now.
Yeah, there I am. Okay,
My
cool.
bad.
Good. So in relation to collections and small claims, can a lease provision or a provision in an addendum provide that the tenant will continuously update the landlord in writing as to their current employment and where their employment is, the name, address, telephone number of their current employer, whoever that is, if they change jobs during the tenancy, and also if they change banks and have new banking account, would that pass constitutional muster in terms of the appellate court? And if so, how would you, well, I know I can't ask this specifically, but can that be put into I know this is the case because tenants will change their banks if they know there's going to be a fight with their landlord, they will change banks and do things such that it will make it hard for the landlord to collect on even a judgment in the future. That's my first question. The second question
Well,
is,
let's do one at a time.
okay, okay,
Okay. First of all, is it legal to put a clause like that in a rental agreement? And I say it is perfectly legal because it's in my rental agreement
okay,
that upon the request of a landlord that you have to fill out new information. So who knows if they're going to fill it out correctly, but if they don't supply that, that would be grounds for eviction.
okay.
It's always a good idea for landlords to, if they get a check, to take a photocopy of the check periodically. Because if you take a photocopy of the tenant's check, then you're going to know where he banks and also what his account number is. And even though we're really good at locating those items, it's not bad if you already have it.
Correct. Thank you. And one last question. Um, when you go to small claims, your hearing, how do you exercise your right to have it heard by a well-reasoned judge, an elected judge, not a commissioner, not a pro tem? How do you say it? Is there a certain way to say it? Like I want this heard by a pro tem, because sometimes they want you to take the pro tem because they don't have time. They want you to force. They want
Right.
yeah.
Well, first of all, I'm in agreement with you. Never take a pro tem, and I'm hesitant to even take a commissioner. You have to agree to a pro tem. You have to agree to a commissioner. You have the right to have your case heard by a judge, and hopefully an older judge. The older
Yeah.
the judge, the better the better it is for landlords. Because
Yeah.
if you take a pro tem in small claims court, my experience is you will lose. I don't care what your case is.
Hmm.
So never take a pro tem. For the audience, a pro tem is an attorney, not a judge, not a commissioner, who is graciously giving up his time to act as a judge. So he's like a temporary judge, and he's appointed by the court to do that. And so they call him a judge pro tem. And you have to stipulate to a judge pro tem, you have to agree to it, you have to agree to a commissioner. So just don't agree to it, Sam. What's the
Okay.
next question?
That's it. That's all my questions. Thank you.
All
Happy
right.
New Year. Happy New Year.
Same to you, sir.
Yeah.
And we are moving on to Laura. Laura Corral, how are you?
I'm doing well, Dennis. Thank you for asking. So I have two questions. I'll make it quick. So I have one tenant that um they regularly bring in different contractors, whether it be plumbing or whatnot, to go ahead and fix stuff on the apartment. I've addressed to them in the past that this is not allowable. And my question is that last week you talked about the trespassing arrest authorization form that's on
Mhm.
your website. In order to pursue trespassing, that needs to go ahead and be completed and turned into the LA Police Department, correct?
Yes, you have to do that first. That's a form that's on my website. It's in the legal issues section.
Mhm.
And you filed that, if you have a vacant unit, you filed that with your local police department, and then you have to put up a no trespassing sign. This way, if somebody breaks into your vacant unit,
Okay.
then you can call the police. Normally, the police are just going to say it's a civil matter, go call Dennis Block. But, and they're not going to throw these people out. But if you have that on file, then with the local police department, then you can call that police department to come out there and arrest these people as trespassers.
My other question is in regards to 3 weeks ago, LA Housing Department investigator called property manager about a harassment claim that was submitted. Property manager clarified the evidence that was submitted to by the tenant, which had many inaccurate statements. And the investigator at LA Housing Department said that there was no need for the property owner to submit any evidence or documentation. An informative letter was mailed to the landlord, but in the informative letter, the summary by the investigator says that the investigator spoke to the landlord and not the property manager, and there were inaccuracies in her summary. Should the property owner go to LA Housing Department and get the summary that was written by the investigator corrected, or just leave it as is?
Well, the investigator said that there's not going to be any charges filed, correct?
Right, that
Okay, well, I would write a letter. There is a complaint number. I would just write a letter to them to clean up any inaccuracies. So that's in your file. Otherwise, there's really nothing else to do.
got it. Thank you.
All right, Laura. Happy New Year to you. We are moving on to Margaret O'Brien. Margaret.
Um, I have 5 unit building in San Pedro under rent control, and there is one couple, and they're always doing things they're not supposed to be doing. The son had a barber shop set up in the garage without my knowledge, so I had that cut down, closed, told him you can't do that. And now the son has his girlfriend and child move in, and they keep telling me they are not living there. And the parents have now started to sell tacos out of the garage on Saturdays and Sundays. And I do know people can sell food, but don't they have at least to have a permit? I mean,
Well, whether they have a permit or not is not your concern. Your concern is that you rented the premises for residential purposes only. And if
yes.
they're conducting business by cooking food for sale, whether they have a permit or not, then in that situation, that's grounds for eviction. So you actually have two causes to evict. And one would be the unauthorized persons who are there. And the fact that, they say, well, they're not there, they're just guests, or they come and they go. You know what? I can tell you that I was born on the planet Mars. The fact that I'm saying that doesn't mean that it's true. So as long as you can establish with your two eyes that those extra people are there, those strangers are there, that's all the proof we need. Two eyes. If you got another person who can come to court to say that they see the same people in the morning and the evening, maybe you know what car they drive, and we all know that wherever you are, your car is. Just like everybody who's watching me now, your car is right outside. So if you see the stranger's car parked, assuming he has this car, then you know he's inside. So on that basis, you have a good case for eviction if that's what you're looking for.
Okay. Okay. So do I need, for instance, proof about the selling of food?
Again, you just need to see, you're going to have two eyes or pictures with them coming
Okay.
out with their cart. Okay.
Okay.
Also,
Well,
when they do this, the water usage in your building is so much higher because of that, which you're paying for, of course. So it really becomes taxing to the landlord.
okay. Okay. Thank you very much.
Thank you. Anna, say hello.
Hello, Mr. Dennis. Have a
Hello.
Merry Christmas.
Same
Uh,
to you.
I have a question for my friend. She not able to come to speak with you. She has a tenant, actually previous tenant. The lease it was signed several tenants, but it's a same family. So after vacate the property, one of the tenant lawsuit her and
I didn't understand that last sentence. You said lawsuit? I didn't hear.
sue them. One of the tenants sue her, the landlord.
Okay, first of all, what city are we talking about?
Is in Los Angeles County,
Not the city. It's in
not
county.
the city. It's county. Yes.
So it's unincorporated. So what did this tenant sue you, the landlord for?
I believe breach of contract or something like that. I'm not sure,
Uh,
but the
Okay.
main point for they lately they accepted her written offer, but after accept the offer, they denying to sign release and settlement agreement from all tenants. So what her options?
I'm not following this. You're saying something about a release. Release of what, please?
Like release for future claims or something like that, settlement agreement.
Is this in terms of trying to settle the suit that the
Yes,
tenant brought?
yes.
Okay, well, it takes two people to settle. If they're not willing to do a full release, then your friend shouldn't settle the case. But it's kind of the question that really I need to have more information, Anna. So maybe your friend should call us at the
Oh,
office.
okay.
All right,
What's
thank
the
you. Sorry, darling. CY, we're going to open it up to you. CY, are you there? Okay, CY.
Hi,
Oh,
hi,
there you
I'm
go.
here. Sorry, I just had to like unmute it. How are you? Thank you for taking my call. I wanted to ask you a question because I have a an apartment complex that has 4 units in Montebello, and I have a tenant that's been there for 7 to 10 years. I can't remember exactly how long. She's been fine. She pays rent. Everything's fine. But recently, I hear that she's become kind of schizophrenic, and she has some kind of issue with at least one of the tenants because that tenant keeps calling me where she is becoming aggressive and violent. She's been called, the cops have been called out many a times. She's broken their windows. She carries around a bat. And I seen it because I put some cameras up in the units and I see her and hear her becoming violent, aggressive, cussing constantly. And she runs out of her unit. Basically, she's aggressive and hostile. The police have come out several times and I think she's been taken away. So as a landlord at this point in time, what is my responsibility in regards to her behavior and how she acts on the premises? And is there any liability that could fall upon me if I don't take any action? So that's my two questions regarding that.
Well, my response to you would be run, don't walk, and start an eviction case right now, just for the safety of your own tenants. You don't
Mm-hmm,
want this person here. And what is that doing to your property and your
mm-hmm,
business? You're the business of landlording. So
mm-hmm.
it seems like you have an easy case to bring forth a case based on nuisance where you'll just be able to evict this person. What is your liability if you know that somebody has this propensity and you've obviously gotten complaints from other tenants and you chose to do nothing? Well, guess what? If somebody gets injured, you're going to be sued in this lawsuit too for failing to take action when you knew this person had a propensity for violence.
Okay. Before I take action, do I have to give notice to her? Like,
No, I mean it's kind of like um, somebody like shoots up the place. You don't give them a notice like, "Hey, please stop doing this." There's no warning necessary. The person's an idiot and it's mental problems. You need to immediately commence an eviction. We would be serving on her a 3-day notice to quit, giving her 3 days to vacate, which of course she won't, and then proceed forward with an eviction. I can tell you though, my experience with people who are mentally off is that we never get a big fight in court. It goes very smoothly.
okay. All right. So I don't have to write her a letter like this is what I've seen or heard. Just do a 3-day, start an eviction, based on nuisance, you're saying.
Right. And we're going to need to have other tenants be cooperative. If push comes to shove, in a small percentage of cases, I would need some tenants to come to court, but it's a small percentage. If they don't come willingly, we can always subpoena them.
Okay. Would video camera footage,
Camera footage would be okay, but is it really going to show her, reeling off and running after people?
yeah. It
Well,
does.
and that would be good, but I would still want a witness.
Gotcha. Okay. All right. And if the witness doesn't come up, we can do a subpoena.
You got it.
All right. Thank you very much for your time. I'll be in touch. Thank you.
Okay, CY. Happy New Year to you. Michael and Sarah, say hello.
Hello.
Hey, how are
Hello,
you?
Dennis. Yeah, thank you very much. Happy holidays, happy Hanukkah to you and yours.
Thank you.
Good to see you. By the way, since you came back from the vacation, you look much younger. So you should take
Well,
more
well,
more
well,
vacation.
thank you. I'm on a big diet, so we'll see how that goes.
Yeah. My question is, we have a condo in Tarzana. It's a one-bedroom condo. It was built in 1973. Is this under rent control? That means we cannot raise it as much as you want?
Okay, first of all, you are under the rent stabilization ordinance for the city of Los Angeles. You do have to register that unit. You have to send a copy of that yearly registration to the tenant. However, if you're a condo, I don't care whether you're under RSO or not, or a single family home or a townhouse, you are not subject to rent limitations. You can raise the rent as much as you like. If you do raise it above 10%, more than 10%, it's a 90-day notice plus 5 days for mailing. If it's 10% or less, it's a 30-day notice plus 5 days for mailing.
So it doesn't matter if it was built in 1973 or 1990.
No, it's just if
Oh,
it's a condo under the Costa-Hawkins law that, thank God, didn't get voted out, there is no limitation on rent.
Oh, okay. If we want them to move out, there is a couple and 2 kids live there, and the rent is under market.
Yeah, but you already have an easy way of fixing it. Just raise the rent.
Oh, I see. Okay. Okay. My next question is that we have raised a townhouse in Panorama City more than 20% in May of early this year, but the tenant still paying almost 5% less because she doesn't want to pay what we ask for to pay. So since May, every month I send them a bill that they are under $250 less what they're paying. So as of right now, they owe us just about $2,000 past rents. So is this time to evict them?
Well, it's whatever you want to do, but the answer is you have the legal right to evict them.
Okay.
What I would be doing is, for example, in January, I would not accept any rent in January at all, and I would serve a 3-day notice that encompasses all the deficiencies for the previous month, then plus
Oh.
January. So now you'll be above the threshold. So that's something that we could start as early as January 3rd.
Oh, okay. Thank you very much, Dennis.
Okay, Michael, nice talking to you. We are moving on to Gid Martin. I'm going to ask you to unmute yourself. Gid Martin. Hit the unmute button. Last chance, sir. Okay, well, there you go.
Okay, sorry about that. Excuse me. Thank you for your service. Happy holidays. Mine's just real quick. I do have an $8,000 judgment, and thank God I was able to get the tenant out. Um, and I'm wondering, do you guys charge a flat fee, or is there
Well,
a
most
percent?
collection agencies, and we're like most collection agencies, we do not charge any upfront fees.
Oh, okay.
And we'll run that check, as I said, every year until we collect, but there's no upfront fees that the owner of the judgment would ever have to pay us. We do it on a contingency fee basis, and it's 50%.
Oh, that's not bad. That's very good. Okay. And then the last thing is, this is probably beyond your scope. It's HOA. I'm being harassed, and I'm wondering if there's a governing body or someone you can refer me to address. I keep getting violations that they're not my responsibility. My place is vacant, so there's nobody putting trash out. It's very weird.
If you call me at the office, I can give you a referral to people who deal with HOAs.
Okay, and just call the regular office number.
Yes.
Okay, thanks, man.
All right, you take care, sir. Moving along to McGrath. Jay McGrath, I'm going to ask you to unmute yourself. You can say hello. Mr. McGrath, you have unmuted yourself, but you have a problem with your microphone because
Hello, can you hear me? Can you hear
Oh,
me?
now I can.
All right, so I inherited these buildings from my grandfather. He owns them in like Dorchester, Massachusetts, if you know what that is. It's in Boston. Um, Basically, I have these two tenants who haven't been paying rent, and like the it's under market value already, like because the market value in Boston
My
is like going
good
up. Like,
friend, I am a California attorney.
oh, okay.
And if this is in Massachusetts, where are you calling from?
I'm calling from Boston right now.
Okay, well, I'm glad you found me.
I don't know how I found you, but I did.
And I would be happy to help you, but I'm sure they have rent control issues there, and I obviously wouldn't know it since I'm strictly in California, know the laws here, but not there. But
All right.
I appreciate you watching.
Okay.
And is that your daughter there that I'm looking at?
Oh yeah, yeah, yeah,
She's very pretty. Say hello for
yeah.
me.
All right.
Take care. Okay, moving along to Martin Adlitz. I'm going to ask you to unmute yourself.
Yeah, hi Dennis. Happy New Year. A question. I've got a 9-unit in Long Beach. Tenant's been there for a while. She seems to have a new friend. When he comes by, he doesn't bother anybody, but he yells and screams and cusses at people. Anything I can do at all?
You said he doesn't bother anybody?
Well, I mean, physically.
Okay, so well, sure. I mean, if her invitee is bothering other tenants, you need to send a warning letter to your tenant and say, this stops now. So either have them not come or tell them to shut up. But if it happens on the next occasion, we're going to bring forth an eviction against you. We don't have to have the other residents in our building terrorized by your poor choice in boyfriends.
Okay, thank you. And again, Happy New Year.
Thank you, sir. Good question. Moving along to Nooni. I'm going to ask you to unmute yourself.
Hi, Dennis. Thank you for taking my question.
No problem.
So I have a unit in Barstow, California.
Sure.
And so I have a tenant that texts she told me that she was moving out as of December 31st. She texted me December 17th. So I just said I wanted her out, so no problem. Go ahead and go through with it. When I told her that we needed to do a walkout, a move out and an inspection, looking at your website, she then said, oh, well, I was hoping that I can move out on January 10th. So I said, well, that will be fine too, but there will be a prorated to rent. So she says, oh, well, let me see with the apartment that I'm moving to see if they could take me earlier to let me move in so I can move out by the 31st. However, when I followed up with her last Monday, now she's not answering.
Well, did she serve you with a formal notice, written notice that she was vacating?
Well, she did a text via text.
Yeah, I don't think that's going to be sufficient. So you really don't have you really can't rely upon the text and her words that she was going to move. So if she doesn't pay you the rent come January, I would serve on January 3rd is the first legal day. You could serve a 3-day notice and proceed forward with an eviction.
Okay. Okay, and then Dennis, I have one other question. This is for LA County unincorporated. I have a tenant there, but the ADU is we didn't get it permitted. So how does that work as far as like trying to get it permitted now? Is that a problem when you're evicting the front unit?
No, it shouldn't have any effect. Right now, the back unit is vacant, correct?
No, we do have a tenant there, but it's a family friend that my husband,
Okay.
he is his caregiver.
Okay, so therefore it's not going to be a problem if you had to get him out.
Mhm.
So yeah, just contact a contractor, and under state law, local governments do have to allow these granny houses to become permitted with
Okay.
some conditions, but generally you can do it. So a lot of people are doing these ADUs, and you want to make it legal because you'd be in a whole world of hurt if you got a tenant in there who stopped paying rent. You'd have to pay him thousands and thousands and thousands of dollars in relocation for the county.
Oh, wow.
Yeah, so
Okay.
go get it legal before you rent it out.
Okay. Sounds good. Thank you so much. Happy holidays.
Same to you. Moving along to Belinda. How are you?
Hi Dennis, how are you?
I am
Thank you for
fine,
taking my
thank you.
question. So, I have a fourplex in Valley Village, and we're currently remodeling the garage to an ADU. And because of this, they're losing parking and storage. And the parking is already sorted, but a tenant is asking for reduced rent for the lost storage. And I saw on LA City they suggested at least $78. And I felt like that was a lot for the tiny little storage in the garage. But is that a must? Is that the
That's
amount?
just their calculation. So you can tell the tenant, I'm going to just give you $50 off or $25 off. Now,
Oh, okay.
if the tenant objects to the amount, and we are talking about the city of Los Angeles, correct?
Yeah, Valley Village.
So what they can do is they can make a complaint to the Los Angeles Housing Department, and then there'll be like an arbitrator who will determine what that value of that monthly storage rate would be.
Oh, okay. And if, because we're planning on doing a new storage in the ADU, and if we put in new storage in there, even though it's not as big as they had in the garage, do we have to reduce it at all just
I don't
because it's
think
smaller?
so. As long as
No?
she can get her stuff in there, I don't see a problem with that.
Oh, okay. Awesome. Thank you so much.
My pleasure. Let's see. John Longbottom, how are you? Mr. Longbottom. Okay, Mr. Longbottom. Oh, there you
Hey,
go.
how's it going?
It's
I have a
good.
question. Can you forcefully like evict a tenant?
Well, I'm not sure what you mean by that.
Like
When you go through
physically?
the legal process, you are forcibly evicting that tenant. You can't do,
Like hire a goon squad to like remove them from the premises.
well, if you did that, then how would I earn a living, honestly? Right, John? But the reality is that in the state of California, you're not allowed to do self-help. Okay? Okay, I guess that was an interesting question. And I think we lost John there. So we're going to move on to Sarah White. How are you?
Hello?
Hello, Sarah.
Hello. Alright, so
I see this is going nowhere, Sarah. So I am going to mute you. And we're going to go now to I don't even want to pick you. We're getting some interesting people here today. Let's pick on Doug Whiting. Say hello.
Can you hear me now?
I can.
Okay, thanks, Dennis, and Happy New Year. I have a question. My wife and I are looking at possibly moving out of our house in Carlsbad for a couple of years. We might end up staying there, or we might end up going back. We'd like to rent it out for 2 years. In California, or in, I guess, San Diego County, is it allowed to have a agreement that doesn't become month to month? In other words, if you have a 2-year term,
Is it a single family home?
single family home.
Only one house on the lot?
Correct.
Okay, so when you rent it out, yes, the answer to your question is yes, no problem that at the end of the 2 years you can say, hey, move. However, um, you have to have a phrase in your rental agreement that this property is not subject to statewide rent control. So if you get my rental agreement, which is free and online at evict123.com, go to the back and there's a little box to check, because single family homes are not subject to statewide rent control if you check that box. And if that box is checked, then you'll have no problem.
Okay. All right. Great. If the time comes, I'm sure we'll contact you and make sure we get it right. So thank you.
I appreciate that. Okay, let's move on to Cynthia's iPhone. How are you?
Hey, hi. Can you
Hello.
hear me?
I
Hi.
can.
Okay, so I have a tenant in one dwelling home, and then I give the offer to move out by December 31st because she's not paying for 4.5 months. We free all the rent and then we will return the deposit. But 2 days ago, she said I cannot move, Cynthia, because I don't have place to go. So what is your suggestion?
So first of all, this tenant owes rent, correct?
Yeah. And then it will be end March 2025 for 1 year, but she's not paying for 5 months now.
Okay, so we need to serve a 3-day notice to pay the rent. And
Okay.
then at the end of the third day, we have the right to bring forth an eviction. That's the way this would work, okay?
Okay. So call your office to do the 3 days and then evict her.
Correct.
So one more question, because before, to make her private, we closed the door between our home to her the addition room. So now we need to reopen that door.
Well, I mean, when you say you closed the door, did she have access to the whole house before?
No, before she in, we close it.
Okay, so it's just a house with her
Addition
living
room. Yeah.
with one room, and it's just a door that's closed. Well, if it was always closed, you don't have to open it now because it was never open, correct?
Never open, but in the permit they're supposed to have a door.
Well, do you have a door or do you have a wall?
Before is a door, and then we close to the.
Okay, when you say close it, what you really mean to say is that you put a wall there.
Correct.
You made an illegal unit in that situation, which
Oh.
means the tenant has no obligation. This is in the city of Los Angeles?
Yes.
That means the tenant has no obligation to pay rent. And you have to pay the tenant thousands of dollars in relocation. What I would do is I would go over to the tenant and see if you can make a deal for the tenant to move. Maybe you want to even give her a few bucks. But if she says no, you're going to have to go through the formal process to evict her, which of course my firm can do. But when you put that wall up, you made an illegal unit, Cynthia.
Oh, but I call one of your attorney. They said just open it now.
Well, if you can open it now, but is the wall on your side? Is the door still there, or did you remove the door?
Remove the door.
Okay, no, you can't do it, my love. I would try to offer her some money to move. Okay, otherwise you're gonna have to go through a formal eviction. We're gonna move on to Andy. I'm gonna ask you to unmute yourself.
Hi, can you hear me?
I can, Andy.
Hey, thanks for doing this. My question regarding collecting a judgment, since we talked about that today when you first started. I can run AOA credit reports here in my office. Is it a permissible purpose because I have a sizable judgment to run a credit report?
You can only run a credit report if you have permission from the person who you're running. So generally on an application that they sign, they give you permission to run that credit report, but you can't run it now.
So just having the judgment is not a permissible purpose. And
No, because that's only for checking. There's specific grounds upon which you can run a credit report. For example, I am not allowed to run a credit report, even with all my licensing, on a applicant. I can't run it on an applicant, but I can run it on a judgment. So you have to be approved to run it on a judgment. Otherwise, you're going against the Fair Debt Collection Practice Act, and you can be fined.
Running it on a judgment is a different approval than running it on an applicant.
That is correct.
Okay, so when you started today, you talked about a lot of things that would appear on a credit report that you run. When I run the AOA credit report, I generally see revolving debt, installment debt, that kind of stuff. But
Exactly.
you talked about being able to see bank accounts, employment, real property, and addresses.
That's accurate. That's how collectors find assets. So we're running credit reports to find assets. You're running credit reports to see if the person is a good credit risk.
Okay, so I'm looking at a totally different report than you're looking at when I run mine.
Absolutely. Anyway,
Okay,
thank you very much. We are at the end of the hour. Sorry that I didn't get to everybody. We're going to pick it up next week, Saturday at 3 p.m. I'll have a new topic that week. I want to wish everybody a very happy New Year's and a prosperous year. We'll see if we can stay ahead of all the bad legislation that's coming at us. And with that, ladies and gentlemen, take care, and I'm signing off.